because of just the sheer amount of money that was flowing into elections, John McCain and Russ Feingold, a Republican and a Democratic senator, joined together in a really Herculean effort to pass what was known as the Bipartisan Campaign Reform Act, sometimes known as McCain-Feingold, that did a number of things. One of the things that it did was it prohibited parties from taking soft money donations, that is, unregulated contributions used for party building activities or for education. It mainly prohibited national parties from doing that. So state level parties can still take those kinds of contributions. It prohibited unions and corporations from spending money on electioneering issue ads in the lead up to elections, and a number of other things. And Citizens United, the case that really has changed the landscape for political finance, for campaign financing, for the past 10 years, emerges as out of a legal challenge to the McCain-Feingold campaign finance reform legislation. It originated with the 2008 presidential primary election, not even the general election, but during the 2008 Democratic presidential primary, a conservative advocacy group called Citizens United, they're still around, wanted to air a 90-minute long movie attacking Hillary Clinton as unfit for office, called Hillary Clinton, the movie, which was going to be made available on demand via cable. And they intended to air promos for the movie within 30 days of the primary elections, which would have put it in violation of McCain-Feingold. Citizens United filed a lawsuit in DC District Court against the FEC, seeking to overturn the portion of the Bipartisan Campaign Reform Act that bans corporations and unions from electioneering communication within 60 days of a general election or 30 days of a primary. The court ruled that the movie and the ads for it would violate McCain-Feingold and granted summary judgment to the Federal Election Commission. The Supreme Court took up the case and heard oral arguments in March of 2009. And then in January of 2010, January 21st, 2010, the Supreme Court, by a 4-5 decision, a very partisan party line decision with all the conservative justices and Kennedy as one of the conservative majority, sided with Citizens United. And it ruled that any and all prohibitions on independent, uncoordinated corporate and union spending on elections, such as those contained in McCain-Feingold, violate the First Amendment. But it upheld the portions of McCain-Feingold that had to do with transparency and disclosure. In his majority opinion, Justice Roberts wrote the following: prohibition on corporate independent expenditures is, quote, a ban on speech. Quote, if the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. McCain-Feingold had actually included an exception for media corporations. And the court said, if we upheld McCain-Feingold, the courts would have to decide who was and was not a media corporation, which would of course be a problem. And they, in Kennedy's majority opinion concluded that it's not for the courts or legislatures to create balance or fairness between different speakers by restricting speech, and said that concerns about corruption and the appearance of corruption were misplaced because, quote, there is no such thing as too much speech.